Welcome back to another episode of Pragmatic Optimists. I am Rachel Cohen, here to talk to you about the legal side of things, and joined by...
I am Tiara Mack, state senator in Rhode Island, and I'm here to talk about the legislative side with Rachel.
So today we're going to tackle Skrmetti v. United States, which was, I'm going to double check to make sure that I actually got the caption of that case correct. No, United States versus Skrmetti, excuse me, mixed up who was petitioner versus non. So we're going to talk about Skrmetti, which is the case that you may have heard of related to gender-affirming care for minors in the state of Tennessee. I'm going to give a very high-level overview, and then Tiara is going to talk about what legislation currently looks like at the state level related to transgender individuals. This specific case is about a law called the Prohibition on Medical Procedures Performed on Minors Related to Sexual Identity. And I think that there's a really interesting kind of piece of branding discourse here, because the case itself, it says performed on minors, but this case is related to hormone blockers, puberty blockers, things that are not, I think, something that we would consider to be performed on minors. This is about very general gender-affirming care to delay puberty for children that have identified that they are trans. And we are seeing, I think, the name of the bill itself gets at this kind of scare discourse that we're seeing across the country related to gender-affirming care for individuals broadly, and particularly for children. And Tiara can give kind of an overview of what that looks like across the country and some particularly scary bills that we've seen come into the public discourse over the last couple of months and years. And then after that, we'll get into what the case itself means and hopefully leave you with some optimism at the end.
Yeah, the hope is to leave you with some optimism, but also talk about what kind of crazy town world we're living in right now. So this case originates from Senate Bill 1 passed in Tennessee in 2023. And I went through and read the piece of legislation that this case was based on. So in 2023, just like across the United States, there were over 600 anti-trans pieces of legislation introduced across 49 different states, 87 of which passed. Senate Bill 1 was one of those cases targeting the trans community, specifically trans youth. It was introduced by Senator Johnson in November of 2022, and then the legislative session kicked off in 2023. Some of the quotes in the actual piece of legislation under legislative findings are absolutely wild quotes. One is that the state finds that that gender-affirming care is problematic and has led to suicides amongst young people due to the David and Brian Reamer case, which is a wild case in and of itself that is actually not about trans individuals. It's about a botched circumcision gone wrong, which another side note and caveat we can get into at another day and time, of having genital mutilation surgery, aka circumcisions, on infants who cannot consent to these surgeries. That is not a case about trans individuals. Some of the other cases, or some of the other legislative findings that the bill quotes, is that the pharmaceutical companies have contributed to the opioid epidemic, and they want to protect young people, including trans people, from the opioid industry because of the opioid crisis, trying to link these two things together. And I'm just like, who are these people who have read one headline of a Fox News clipping and decided to make that facts and data in order to have a piece of anti-trans legislation? Some of the other troubling things listed as legislative findings were, and I quote, the state has a legitimate, substantial, and compelling interest in protecting the ability of minors to develop into adults who can create children of their own. That is one of the most troubling statements. The only reason why we are raising children in the first place is so that they can then breed more children. That is something straight out of the Tennessee legislature, and that's at the preamble of the piece of legislation that is trying to take away gender-affirming care from young people. So the basis of this case is not only on pseudoscience, it's just based on the idea that young people are only here to procreate and give birth, and it is citing tons of other non-factual things. Rachel, did you know about this part?
No, I didn't. And I think that it's making me jump to something that I was going to bring up at the end of our conversation about this, which is Justice Thomas's concurrence, where he focuses so much on this idea that he basically writes a concurrence to say the court should not be discussing the science of these things. The science is still ongoing. We don't actually really know, and we're supposed to defer to the legislature. And that, given the context that you've just provided us with, is particularly troubling. But then what's so, I mean, I would say crazy, but it's ultimately extremely predictable, is that then Justice Thomas goes on to write 20 pages of the most like bullshit science you've ever read in your entire life about how gender affirming care is ultimately really harmful for youth, or it's at least disputed whether or not it's helpful, despite the fact that even if we look at nothing else, it's indisputable that giving children gender affirming care saves lives because of the incredibly high percentage of trans youth that attempt or complete suicide when they are not given gender affirming care. And I think that to kind of put all of that to the side and then argue about, you know, Justice Thomas dedicates part of that concurrence to, sorry, I live on an alley. Thomas dedicates part of that concurrence to discussing the efficacy of surgery on minors, which is not at issue in this case, nor is it remotely common. And I think that that's, again, like this big Republican scare tactic, acting that when we're talking about acting like when we discuss gender affirming care for minors, we're talking about some type of dramatic surgical alteration, when the vast majority of the time, what we're actually talking about is delaying puberty so that there are not irreversible changes, or changes that are only reversible to children's bodies, reversible with surgery when they are adults. It's much less invasive. And I think that that kind of goes to something that you had flagged when we were prepping for this episode, which is the Texas legislator, because I think most of the time when there are, and I, you know, could be wrong here, but I know that when there's surgical interventions, it's often related to people who are intersex or similar, which the Texas legislature doesn't seem to know exists.
Oh my God, that was one of the funniest moments of like this legislative session that was caught on camera. So a Texas legislator is testifying about anti-trans surgeries and them being harmful, yada, yada, yada. I didn't listen to this part, but one of the women also in the Texas legislature says, but what about intersex people? And he's like, I don't know about that. I don't know about intersex people, which the intersex is just as common as twins in a population. So if you know any twins in your life, you know someone who is intersex. And so the fact that we have state legislators, and again, state legislators are part-time in the majority of states. There are only a handful of states that have a full-time legislator. So these are people who work full-time other jobs, are not career politicians, did not go to school to be like elected official 101. So they don't always have the necessary background expertise that they need, but to literally go up and say that you want to protect children, while the majority of states, I only know of 2 hospitals that even prevent intersex surgeries, Boston Children's Hospital and a hospital in Chicago, due to some of my folks at Intersex Justice and Interact, who are doing amazing work protecting intersex people from unnecessary surgeries. And to get back to the David and Brian Reamer case, that was a case about 2 twins who were born and were set to have a circumcision, circumcisions, but they had atypical genitalia. And so the doctors wanted to perform this different type of circumcision. They end up botching one twin circumcision and deciding to raise this child as a girl, because they botched the circumcision and had the surgery to basically reassign the gender of a infant who did not want to be reassigned their gender, and then eventually grew up to say, actually, I feel more like a boy, and has a twin brother that they're growing up with, going to gender reaffirming classes. It's pseudoscience to the max, and it's turned out to be a really harmful study. And both twins have lifelong impacts due to this surgery, stemming from an unnecessary surgery in their youth. So when we talk about protecting young people, the conversation is often not focused on protecting the most marginalized, including intersex individuals who are forced to have the same surgeries and procedures that we are withholding from trans individuals. So this conversation, I think, is so nuanced.
No, definitely. And I think that, just to really close the loop and then get into the case, I think that when we assign this incredibly rigid gender binary that has no real upside whatsoever, it does not harm me as a cis woman, when people are trans or are non-binary or have any gender identity that is separate from my own, when we force this rigid gender binary on children to quote unquote protect them, that is the thing that is ultimately very harmful. And when instead we provide children with access to relatively non-invasive gender affirming care, it saves their lives. And so I think that this case specifically is focused on trans individuals and on gender affirming care for minors, but it's opening the door to broader conversations about the LGBTQ community and what they're going to face in this Supreme Court. So I want to run through how this case was decided, and then also the concerns that I have for broader LGBTQ community members as this Supreme Court continues to address issues related to sexuality and gender when they clearly, like many, many legislators in our country, have no fucking idea what's going on and refuse to investigate or dig deeply because they are so unwilling to consider things outside of this kind of rigid gender binary that they're used to experiencing and trying to force onto everyone else. So we need to understand the Equal Protection Clause, which is the portion of the 14th Amendment of the Constitution that says states can't deny people within their jurisdiction equal protection under the law. And what that has been used to do is to assign different standards of review. When the court is reviewing legislation that is allegedly discriminatory, there are different degrees of review that they need to give to it depending on what group is being discriminated against. So there's what's called suspect classes. That's almost always classifications that are based on race. It can also be classifications based on national origin or citizenship status. And those have to be suitably tailored to serve a compelling state interest. And basically, it's very difficult to discriminate based on race in formal legislation in the United States because it's subject to this more stringent standard of review, which has also, as we know, been weaponized in affirmative action cases recently, but we could go for ages on that, so I'm going to leave it there. Then there's what's considered quasi-suspect classes, and these are basically sex-based classifications, and those need to be substantially related to important governmental objectives. And then basically everything else is subject to rational basis review. So rational relation to some legitimate end. And just like it's very hard for a discriminatory law to be upheld on the suspect when it's a suspect class, and thus you have to give it the substantially tailored to serve a compelling state interest level of review, it's very difficult to get a discriminatory law rejected when it's subject to rational basis review. It's very easy for the government to say that there's some legitimate end and that they are discriminating or classifying people differently or treating them differently for some rational reason that's related to that legitimate end. And when this case was argued, Skrmetti, the family that was arguing against SB 1 in Tennessee, was arguing that this was a sex-based classification because there is some precedent that would make you think that LGBTQ individuals are subject to this kind of quasi-suspect class designation, and thus anything that is discriminating against them has to be substantially related to important governmental objectives. There was an employment case called Bostock a couple of sessions ago that relied on the idea that you couldn't discriminate against queer individuals or individuals who were interested in same-sex relationships, because if you switched the gender of that person, then you would not be discriminating against that person. So I think it's better instead of just like explaining at that level. Basically, Neil Gorsuch says this has to be a sex-based discrimination because you're saying that you're discriminating against a man who likes men. If that person was a woman and it was a woman who liked men, that person wouldn't be discriminated against. Therefore, this is obviously sex-based discrimination. But that was rooted in employment law. And so people have been saying, does that mean that outside of employment law, LGBTQ individuals are, when they're discriminated against, are sex-based? It's considered sex-based discrimination? Because if so, that's a higher bar than this rational basis review. When this case went to the Supreme Court, people thought that they might reach that question. What degree of kind of review are laws that discriminate against LGBTQ individuals subject to? Instead of reaching that question, the court says, not relevant. We don't have to touch this because this isn't discrimination based off trans identity. This is just a restriction related to minors. And we have said many times that age-based discrimination is subject to rational basis review. And the prohibition on hormones is related to specific medical uses. It has nothing to do with whether or not the person is trans. The dissent obviously says that's bullshit. You're only saying that you can't use these hormones to treat trans identity. But the majority opinion says we don't have to reach that at all. And one of the things that is problematic and that is concerning, some pragmatic realism, I would say, is that the Supreme Court last week granted cert, which means that they will take up 2 different cases that explicitly ask the question of what degree of review LGBTQ or specifically trans individuals and laws discriminating against trans individuals, what level of review that's subject to when there are equal protection claims. And I will wrap after I make one point, which is that I think that a lot of the time people are tempted to sell out trans individuals because it is a very small minority within the United States, people who are trans. And it also is, because of that, I think a group that is relatively less popular, has achieved fewer gains in terms of acceptance in popular society than the remainder of the LGBTQ community. And so what we end up seeing is that many people of a variety of identities, Democrats, other members of the LGBT community, and particularly cis individuals, cis Democrats, are willing to say, well, we don't want to, let's compromise by selling out trans individuals in a way that is not only unethical, but also now is opening the door for the court to decide what standard of review all LGBTQ individuals or all discrimination against LGBTQ individuals is subject to by using the trans community as their scapegoat. Because I think that it's possible that when the court decides those cases next session, they decide for all LGBTQ individuals. I think that it's most likely that they say, well, trans individuals are subject to rational basis review. And we haven't reached the question of what level of review other queer individuals are entitled to when laws discriminate against them. But they have set the precedent that they can rely on to then find the same thing for the remainder of the LGBTQ community. And I think that it is a powerful reminder why we do not sell out particularly small minority groups and instead constantly prioritize the humanity of every single individual when we are advocating for people. And so I think that I've left us at a place that is perhaps a little bit pessimistic to realistic, but I'd like to now talk about some of the ways that people are fighting back and protections that are available at the state and local level, because this type of decision and this classification of level of review only applies to challenging discriminatory laws. So it doesn't prevent people from putting in affirmatively protective laws to protect those communities.
And Rachel, that is a perfect transition to us talking about what can we do at the local level? We are pragmatic optimists, or praggies, if you will. We are, maybe you won't.
I'm allowing it, but we're on board.
We're on board for praggies. So praggies, what do we do now that we know what is at stake and who is at stake? We have decided as a small minority of the country to start throwing less than 1% of our population, trans youth, under the bus for the sake of some nefarious subplot to make us all not believe that every single person in our communities is deserving of equal protection and equal rights. But states are fighting back. Since the onslaught of anti-trans legislation in our country, there have been, like Rachel said, affirmatively protecting bills passed in states across the country. Especially after the fall of Roe in 2022, there have been states that have passed protections for providers of both abortion care, and there have been a subset of states, so 18 states have done protections for abortion care providers in a thing called SHIELD laws. And then an additional 8 states have also worked to protect protect LGBTQ plus or gender affirming care and their providers. And so what that looks like is state legislators, and in one case that we will highlight with our friend Willie from Somerville, a city council who have said through ordinance that they are going to uphold the right to body autonomy for our trans and gender nonconforming individuals. And this is what we can do to fight back. We are not hopeless. We are not helpless. And there are real tools that you can engage in and encourage your state elected officials and your local elected officials to do to pass in their states. So what is a shield law? These shield laws, again, were enacted mostly after the fall of Roe, but also in response to protecting our LGBT plus communities. They are explicit provisions for protecting patients, no matter their location. And in some states, they also include telehealth provisions. So a doctor who performs or consults a patient who is based in one of these protected states can also provide that same level of care through telehealth. These are protections for out-of-state investigations and prosecutions, protections against professional discipline, protections against civil liability, protections against professional liability, health insurance and health plans, protection of medical information and other data related to reproductive and gender-affirming care. And like I've said, there have been states, mostly in the New England region, Massachusetts, Connecticut, California, and I will put a link to all of the states that have passed this. But if this is model legislation that you'd like to see introduced in your state, you can really copy and paste and go to some of our organizations who are leading the charge on this. I can point to GLAD Law. When we passed this law in Rhode Island, sponsored by Senator Don Oyer, we passed it in 2024. We did it in coordination with experts, legal experts who work on these pieces of legislation all the time and across the country, who help draft our legislation, who help create fact sheets, and who help counsel legislators on what actually the conversations we should be having. And I will say this until my face is blue. State legislators in the majority of states are part-time. And so they do need help and extra resources in order to learn thoroughly about these issues. It's really easy to see how our communities have become super politicized, but not activated with real facts and data. We also, at the same time, see the polarization of information in our country, where half of our country believes in a set of facts and the other set of the country doesn't believe in science, data, etc. And so we have to do the legwork, whether you're a community member, whether you're another elected official, or whether you're someone who wants to get involved, either by having a coffee chat with your elected official. These are some of the tangible ways that you can bring the conversation one-on-one, make the conversation personal, and also get real tangible action. You can do something like have a coffee chat with your city council member. In Somerville, they passed in 2022, even before some of these shield laws, an ordinance protecting gender-affirming care at the local level. And then the state of Massachusetts, where Somerville is located, then passed a statewide protection for gender-affirming care. And then a few states also followed suit, 8 states to be specific. And these are all, again, in coordination with organizations like your local Planned Parenthood affiliate. You can work with GLAD Law, who's a national organization focusing on advocacy. And you can also tap into your local LGBT plus organization, whether it's a PFLAG group or some other LGBT plus organization that is focused on policy and advocacy, to have a coffee chat to introduce the idea of this protective legislation in your state. And I cannot stress it enough that a coffee chat with your city council member, a coffee chat with your state elected officials or your other local elected, some states have county elected officials, is a great way to start the conversation. And this is the off season for most legislators. They end usually around like March to June. Some might extend a little bit later than that. This is a great time to have a conversation, introduce this idea, and start having them counsel with their legal staff in order to draft something that you can be proud of, but also something that is going to have a huge impact for people in your states. And I think, Rachel, is there anything else that we should tell people to keep them optimistic and pragmatic? We've got a really great toolkit that we'll highlight on the side of our page and in our show notes, that you can see some of the model legislation that we're talking about. A coffee conversation might sound difficult, but anything else you'd recommend for folks to take action?
I think that where I would like to leave people is, when I was listening to you talk about coffee chats today, I was thinking we're definitely going to get at least some comments of people saying, I wish I could do a coffee chat, but my state representative is a crazy MAGA fan. My state representative hates trans people. And what I was thinking about was the tipping point that at least you've expressed to me that ultimately made you decide to primary your, at the time, state senator whose seat you now hold. And correct me if I'm wrong, but I think that that had to do with doing the affirmative outreach and being rebuffed. And so not only rebuffed, but with, well, I don't want to tell the story, but it gets a little biblical. And I think that if you have made it this far and you're thinking to yourself, I can't reach out to my state elected official, I would really just encourage you to do it anyway. And even though if you think it's going to be really frustrating because of their politics, you're probably right. Maybe then let that channel you or spur you to other action, which then ultimately might end up landing someone that you do agree with, even if it's yourself in elected office. So I think maybe a good place to close today would be you talking about that letter that ultimately caused you to run for the state house in Rhode Island.
Oh, I love talking about my story to run. I was 25 years old when I decided to run for office because I received a letter right before Rhode Island codified abortion access in our state laws. My elected official, who was anti-LGBTQ and anti-abortion, sent me a letter after sending him a postcard and testifying in front of the Senate Judiciary Committee that had 2 Bible quotes. And at the end, closing out his letter on official state house stationery, said, "I'd rather please God than man." And that was the final straw for me as someone raised in the conservative Christian South, who has my own personal faith practice, to have someone tell me that my rights, my body, and my autonomy was subject to his own personal religious beliefs, and not listening to young people, listening to people who had been through devastating birth experiences and who have devastating stories, bear all in committee hearings, and to double down on his own personal beliefs versus representing the people of District 6, where I now represent, was the catalyst for me to say, okay, well, if not him, who? And I begged so many people. I was like, hey, you gonna run? You gonna run? And ultimately it became me. And I think so many more people are seeing the tides change. A little bit earlier, we talked about some of the pseudoscience and some of the troubling comments that are at the beginning of legislative findings. Most people assume that their state elected officials are professional politicians and went to school to be a legislator. There is no major, at least I don't think so. I haven't done a survey of all of the universities that says like that gives you a degree in becoming an elected official. Your personal experience, your expertise in your own lived story is all that you need to be an elected official. You don't need to have a law degree. You don't need to be a public policy major. You just have to care deeply about protecting your communities and deeply about upholding the rights of individuals in your state, no matter who they are, where they come from, what they look like, who they love, or what name is on their birth certificate. And there are so many organizations prepared to teach you how to run or prepare you to support someone in their efforts to run. I think of organizations like Run for Something, Amanda Littman and Ross Ricchetto were doing a great job of founding that organization, getting young people under the age of 40 to see themselves in office. But there are a host of other local resources who are willing to train people up and see them as someone leading in their communities, because we are not hopeless. But that hope has to come with action. And if you don't see the change that you want to see in your communities, maybe you are indeed the change that you want to see in your communities. And we will continue to provide more toolkits for you to engage in these issues, find out ways to get involved, encourage you to have coffee chats, maybe go on a run, maybe it's a beer with your local elected official. But action is the medicine that we need in these troubling times.
And that always keeps me optimistic. So please go ahead and let us know what keeps you optimistic in the comments. Let us know what you'd like to see more of, hear more about, and subscribe to Legal AF. And you can follow myself and Tiara on TikTok, Instagram, other social media. Our handles have been up on the screen, and we'll see you soon.
Bye, Praggies.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.